Jim, you ready? Rules Committee come to order, and thank you very much for joining us again this afternoon for another fun time at the Rules Committee. Today, the committee will consider H.R. 1215, the Protecting Access to Care Act of 2017. Unlimited medical malpractice lawsuits are hurting a healthcare system already in need of reforms. Doctors are leaving the field because they feel under constant threat of litigation. Further, the endless amount of lawsuits brought against our nation's doctors is increasing the cost of health care and limiting the availabilities of doctors nationwide. H.R. 1215 improves patient access to health care services and provides improved medical care by reducing the excessive burden the liability system places on the health care delivery system. This legislation today before the committee directly benefits both parties and doctors, patients and doctors, by providing checks and balances on unlimited lawsuits that increase what I think hurt the real cost of health care. I would like to welcome today for our first panel the gentleman from Iowa, Congressman Steve King, my dear friend, as well as the gentleman, my dear friend from Tennessee, Congressman Cohen. I want to thank both of them not only for taking their important and precious time to be before the committee today, but really to welcome two gentlemen who've been fighting on these issues for quite some time. They not only represent knowledgeable thoughts and ideas on the issue, but I think both state well their positions, and we're delighted that you're here. So thank you for joining us today. We look forward to your testimony. As always, before we get started here, anything you have in writing will be entered in the record. And I appreciate you helping our new stenographer out, who I believe this is her second time to be before the committee. You would think I would remember the first, but I slept last night. But so our new stenographer, and she's doing an awesome job, but we're going to work with her and let her know how important she is to this process. Before I go any further, I want to yield time to the gentleman, ranking member of the committee, the gentleman from Massachusetts.
Well, thank you, Mr. Chairman. And here we go again. I mean, we've been doing this every year, I guess, for as long as I can remember, but it's part of the Republican majority's greatest hits. But I'll be very brief. I think this is a lousy bill that will undermine the ability of medical malpractice victims to seek or receive adequate compensation for their injuries. And I hope that, after we get this, my friends get this out of their system, that, this bill dies a quick death. So with that, I yield back my time.
Appreciate the gentleman's comments. Death. Okay, Mr. King, I know that you represent the chairman of the committee, Mr. Goodlatte, and we spoke yesterday about your knowledge not only of the subject, but your reliability in provision of this technique to go sell this bill, and the gentleman's now recognized.
Thank you, Mr. Chairman. I appreciate the chance to be here to represent the chairman of the full committee and also to present this piece of medical malpractice legislation to the Rules Committee. First I'd like to point out that this bill only applies to claims concerning the provision of goods or services for which coverage is provided in whole or in part via a federal program, a federal subsidy, or a tax benefit. So this gives it a clear federal nexus. And wherever federal policy affects the distribution of health care, there is a clear federal interest in reducing the costs of such federal policies, as we've seen by our budgets of late. This bill is common sense reforms which have been the law in California for over 40 years. I might point out, signed into law by then Governor Jerry Brown, still law under now Governor Jerry Brown, Governor Jerry Brown, and which the CBO conservative estimates will save $54 billion in federal health care dollars. It includes a $250,000 cap on non-economic damages and limits on the contingency fees lawyers can charge. They provide for a default 3-year statute of limitations with tolling provisions and allow courts to require periodic payments for future damages instead of lump sum awards, so that bankruptcies in which plaintiffs would receive only pennies on the dollar can be prevented. And they include provisions creating a fair share rule by which damages are allocated fairly in direct proportion to fault. And this bill does all this without in any way limiting the compensation for 100% of the plaintiff's economic losses, which include anything to which a recipient can be attached, anything which a receipt can be attached, including all medical costs, lost wages, future lost wages, rehabilitation costs, and any other economic out-of-pocket loss suffered as a result of a health care injury. Far from limiting the deserved recoveries in California, these reforms have led to medical damages awards in deserving cases in the $80 to $90 million range. As reported in the Washington Post a few months ago, I quote, U.S. healthcare spending is projected to accelerate over the next decade. A study by the Center for Medicare and Medicaid Services, CMS, projects that the average growth in health spending will be even faster between 2016 and 2025. The projections are based on an assumption that the legislative status quo will prevail, close quote. As Nate Silver has pointed out in the New York Times, all of the major categories of federal government spending have been increasing relative to inflation, but essentially all of the increases in spending relative to economic growth and the potential tax base have come from entitlement programs. And about half of that has come from health care entitlements specifically, close quote. As health care costs rise, wages fall. As the more companies must pay in health care costs, the less they can pay in wages. Just look at this chart that I have here, Mr. Chairman. This is published in the Journal for the American Medical Association. It shows the benefit of the camera, too.
Gentlemen, hold just a moment, please. If the clerk, Ms. Booth, would please come and get a copy of the gentleman's presentation and make copies for all the members of the committee, and then bring that back to the gentleman for his final presentation. Thank you very much.
Thank you, Mr.
Do you have
Chairman.
anything else, Mr. King?
Pardon me?
Do you have any other pictures that you would like to?
That's all I have
Thank
for
you very
pictures.
much.
And if I could just and then proceed with my statement, in
Yes,
which
sir.
I know the committee will see the chart and recognize the relationship between wages and healthcare costs. They do track each other in an inverse proportion. When wages go up, or excuse me, when healthcare costs go up, wages go down. When healthcare costs, the acceleration of those costs starts to flatten out, wages can start to catch up again. And that's the point of the chart that will soon be delivered to the committee. The top line shows the growth in healthcare costs, and the bottom line shows the growth in wages. I'll bypass some of that until the committee has access to that information, which I see is,
It is
happen
not.
soon.
If the gentleman hold just a second, it is not. It's another amendment, but the gentlewoman will deliver it back to you, and they'll give you notice that we have received it.
Thank you, Mr. Chairman.
Yes, sir.
So as healthcare costs increase, wages stagnate. And when health costs grow at a slower rate, as in the mid-2000s, wages rebound again. Members who want to see wages increase should vote for this bill because one of the drivers of higher health care spending is so-called defensive medicine, a very real phenomenon confirmed by countless studies in which healthcare workers conduct many additional costly tests and procedures with no medical value charged to federal taxpayers simply to avoid excessive litigation costs. A survey published in the Archives of Internal Medicine found that 91% of the over 1,000 doctors surveyed reported believing that physicians order more tests and procedures than needed to protect themselves from malpractice suits, close quote. Let's see. The survey also asked, are protections against unwarranted malpractice lawsuits needed to decrease the unnecessary use of diagnostic tests? Overall, 91%, same percentage of doctors surveyed agreed. And on one Newsweek reporter described the personal experience of individual doctors this way, quote, typical was a doctor who had a list as long as my arm on procedures ER docs perform for no patient benefit. They include following a bedside sonogram with an official, that word officials in quotes, sonogram, because it's easier to defend yourself to a jury if you'd ordered the second one. A CT scan for every child who bumped his or her head to rule out things that can be diagnosed just fine by observation, X-rays that do not guide treatment such as for a simple broken arm, CTs for suspected appendicitis that has been perfectly well diagnosed without it for a long time. Although doctors may hate practicing defensive medicine, they do it so they don't get sued. Nationwide, physicians estimate that 35% of diagnostic tests they ordered were to avoid lawsuits, as were 19% of hospitalizations, 14% of prescriptions, 8% of surgeries. All told, it adds up to $650 billion, That's $650 billion with a B in unnecessary care every year. Another ER doctor said he ordered 52 CT scans in one 12-hour shift. That's $104,000 in a single day ordered by a single doctor just in CT tests. The most recent study, published a few months ago in the Journal of American College of Radiology, studied the effects of tort reform on just radiographic tests alone and found that there were, quote, 2.4 million to 2.7 million fewer radiographic tests annually attributed to tort reforms. Just imagine what savings would occur if such reforms were attached to all federal health care programs, as this bill would do. Regarding how this bill affects state law, H.R. 1215 provides for flexible legal reforms, and for them to be used at the discretion of states, affecting only health care provided pursuant to federal programs, to subsidies, and to tax benefits. Under these flexible reforms, medical lawsuits will continue to be brought in state courts as they always have, but flexible reforms will be in place to reduce the cost of health care funded or subsidized by federal programs. First, the bill does not preempt any state law that otherwise caps any form of damages at amounts either higher or lower than the cap in H.R. 1215. So a state can limit any form of damages it wants at $1 or $1 trillion conceivably, or any other number that it chooses. And such a law is preserved under H.R. 1215. Some 35 states have such caps in their health care litigation laws, and such laws will be fully preserved under H.R. 1215. Second, regarding the other issue areas the bill covers, which as I mentioned previously, if any state has a law governing these same issues, such state laws are preserved when they provide greater protections for health care providers, thereby protecting state reforms in these specific areas that go further than H.R. 1215. Now, I'd point out a couple of things that came to me as I brought this bill forward and through the Judiciary Committee. An orthopedic surgeon has said to me that he does a serious number of ACL surgeries on knee injuries, and he does an MRI before he does the ACL because of the liability. And he said 97% of the time, I know exactly what's inside that knee before I go in there. And I also spoke to an anesthesiologist who practiced in Texas when Texas passed their tort reform legislation, which Texans seem to be very happy with, as are Californians. And in that practice, his premium was $26,000 for a radiologist, for an anesthesiologist medical malpractice insurance. And when the Texas law was passed and implemented, his premium went down to $6,500, exactly a fourth of the premium. So this gives us an idea of what this can do in saving $54 billion over 10 years, hundreds of billions of dollars in unnecessary care each year, and giving people some relief while protecting the individuals that may be the victims of a malpractice and have a just claim. And I think that if this were bad legislation, California would have repealed it, and it's 40 years into this, and Jerry Brown's at the helm, as he was when he signed the bill. So, Mr. Chairman, I urge that this bill be moved forward and encourage its adoption, and I yield back the balance of my time.
Gentleman, just back the chair recognizes the distinguished gentleman from Tennessee.
Governor, it's nice to see you. I appear today in opposition to this bill, H.R. 1215, the craftily titled Protecting Access to Care Act of 2017, which, if it's a good thing for California, it may be, because it's the province of the state, and that's who should be passing such laws as states, not the federal government, and not under the guise of protecting access to care in a climate where we are about to take 23 million people's health care away from them and decimate Medicaid, which would give the least the people that have disabilities, poor people, and pregnant mothers, et cetera, decimate their health care. So this is part of the Protecting Access to Care Act at this time is a misnomer and a calumny. It marks the 12th time since 1995 that the House considered legislation intended to deny victims of medical malpractice, these are victims of medical malpractice and defective medical products, the ability to be made whole and to hold wrongdoers accountable. Instead, it puts some federally devised figure on top of it and superimposes it on whatever the individual in the state's damages might be. Normally, you'd hear the folks who are supporting this be upset about the folks in Washington telling us at home what the damages should be or what should take place. But we've reversed courses here. This is an unusual situation. This measure has repeatedly failed because of its many problems, and it's trampling on states' rights. Nevertheless, the majority now brings this dubious bill to the floor as part of their attempt to repeal the Affordable Care Act, leave those 23 million people without health care, decimate Medicaid, and possibly limit other protections that women have for their health care. This bill will directly impede Americans' access to safe, quality medical care. And there are many problems with the bill, but it would take too long to discuss them all. We only have a few minutes, so I'm going to just talk about some of the more egregious ones. H.R. 1215, like so many other civil justice bills that we have considered, deeply intrudes on state sovereignty. I was a 24-year state senator and came up here one time proudly to see Fred Thompson, a United States Senator from Tennessee, receive the National Conference of State Legislatures Preserving the Balance Award, when he was the only person up here to vote against a nice goody bill that removed tort liability or provided tort liability for Boy Scouts and Girl Scouts, which is nice and politically good, but not the province of the federal government. And Fred Thompson had the guts among all the other members of the Senate to vote no. It doesn't seem like we're preserving the balance in federal and state in this bill. Tort law is the domain of the states. This bill preempts medical malpractice and product liability law in many states. In particular, it preempts state law governing joint and several liability, the availability of damages, the ability to introduce evidence of collateral source benefits, attorney's fees, and periodic payments of future damages. Members should not be fooled by assertions that the bill preserves state law. In fact, H.R. 1215 does absolutely nothing to address the fundamental concerns about states' rights previously raised by members on both sides of the aisle. It intrudes just as deeply as its predecessor bill into areas traditionally determined by the states, and for that reason, among others, the National Conference of State Legislatures does oppose this legislation. The bill's rule of construction expressly states that it preempts state law, except in very limited circumstances where state law is more favorable to defendants, defendants being those people who removed the wrong limb, left a sponge in somebody's body, resulted in some serious medical problem. To them, there is some limited exceptions because it preempts state law for the tortfeasor. But the measure's so-called state flexibility provisions simply reinforce one-way preemption, whereby the bill supersedes state laws that are generally more favorable to the victims, those who have suffered because of some medical malpractice, leaving state laws intact there because they're more favorable to defendants. H.R. 1215's significant intrusion is why the NCSL opposes 1215. It's also why a number of Republicans opposed the bill when it was marked up before the Judiciary Committee in February, including Congressman Louis Gohmert, a member of the Freedom Caucus, and Ted Poe, alumnus of the Freedom Caucus. Further, this bill would cause real harm by severely limiting the ability of victims to be made whole. For instance, it imposes an unjustifiably low cap on non-economic damages. The $250,000 aggregate limit on non-economic damages, an amount established more than 40 years ago pursuant to California statute, would have particularly adverse impact on women, children, the poor, and other vulnerable members of society. These groups are more likely to receive non-economic damages in healthcare cases because they are less able to establish lost wages and other economic losses. Women are often paid at a lower rate than men, even for the same job. Pay equity has not come to this country and are more likely to suffer non-economic loss, such as disfigurement or loss of fertility. Imposing a severe limit on non-economic damages therefore hurts them disproportionately. Whatever the short-term savings, the bill would impose broad social and financial costs in the long term, including additional strains on Medicare, Medicaid if it survives, and other governmental programs caused when malpractice victims are denied full restitution and then must come to the government for additional benefits. Finally, the bill unjustifiably provides blanket immunity for health care providers in medical product liability cases. Hard to understand why a provider who dispenses a defective or dangerous pharmaceutical or medical device should be entitled to a blanket immunity. This provision also has the potential to indirectly shield manufacturers who may argue successfully in a product liability case that a plaintiff's injury can be blamed on a provider's negligence. Because the provider would be immunized, the injured victim would be left without any recovery. The law should not be used to create such an unjust result, which would happen. There are a number of Democratic and bipartisan amendments that have been submitted that would approve the bill somewhat, and I urge the committee to make those in order. Numerous consumer, labor, veterans, and legal groups oppose this bill, including the American Bar Association, not necessarily a real liberal group, the Center for Justice and Democracy, the National Conference of State Legislatures, the Consumer Federation of America, the Consumers Union, the Public Citizen and Vietnam Veterans of America, and AFSCME. So this is a flawed bill that will deny access to justice to victims. It certainly has to deny full compensation for injuries suffered by veterans and military families, children, the elderly, and the poor. And it violates federalism, and Mr. King kind of used a very liberal definition. The federal nexus he drew was a liberal construction. Was certainly not the kind of construction that you normally hear from Mr. King, but anyway, preempt state law with a one-size-fits-all dictate, all the states the same, even those different states have different standards of living and maybe different levels of practice standards. From federal government takes over for the states, and for those reasons and others, I urge the Rules Committee to stop this bill from going forward and preserve our access to the courts and fair justice to those who have been flawed by damaged goods.
Thank you. The gentleman yields back. Preserve the prerogatives of Chairman Sessions when he comes back to ask his questions. And see if the gentleman from Texas, Dr. Burgess, has any questions for either one of these two witnesses.
Thank you, Mr. Chairman, and I do understand the importance of a bill such as this. Texas state law changed in 2003, largely incorporating the changes that were brought about under the Medical Injury Compensation Reform Act of 1974, which, as the gentleman points out, was during Governor Brown's first run as governor of California. Texas did adopt a number of those reforms in 2003, passed a constitutional amendment so that it could not be challenged in the state court, and the result is, over the past 15 years, I think, or 14 years, has been extremely, extremely positive. I guess my questions center around that issue of the 9th and 10th Amendment, and Mr. King, you stated that the nexus was that this applied to federal coverage. Is that correct?
Yes, Mr. Burgess, it is limited to where there is a federal nexus, so that would be anything that has federal dollars in it, federal subsidies, or a federal tax composition in it as well. And I was a little surprised to hear my characterization of this federal nexus as a liberal interpretation of federalism.
Well, be that as it may, I do appreciate the willingness that you have had. I know there were members of my state medical association that were concerned, and I appreciate the willingness that you have had to work with those. Between Mr. Sessions and I, we've got a few of the amendments that are in the queue, and I hope people will look upon those favorably. But I also think, looking at the experience that California and now Texas have had with this, with these types of approaches, I think it has been enormously positive. I mean, I will just tell you, defensive medicine is something that you learn. You learn it through your residency. This is a slow change. It is going to affect the cost curve of medical spending, of healthcare spending overall, but it does occur slowly over time. The studies that I remember are back in the mid-1990s that I think Dr. McClellan, who then went on to become director of the Center for Medicare and Medicaid Services, when he was a Stanford economist, did some of the groundbreaking studies to show the effects of defensive medicine could result in savings of 8 to 9% per year in healthcare spending in the United States being what it is. That is a significant sum. As they say, the journey of 1,000 miles starts with the first step. This is a good step, and I thank you for bringing it to the Rules Committee today, and look forward to hearing the back and forth of the debate on the amendments on the floor. And I think it's an important part of the process that we can do here in the in the people's house. Yield back to the acting
Gentleman
chairman.
yields back. Chair recognizes the gentlelady from New York.
I'd like to ask the chair, if I may, about the $250,000 cap. It's a permanent across-the-board cap on anything, as I understand it, for non-economic damages in medical malpractice cases. Could you give me the reasoning for that?
Yes, and thank you. The reasoning is that there have been large awards that have gone well beyond making a person whole. Someone who is subject to medical malpractice, we want to ensure that we make them whole, that they're compensated for their medical costs, for their loss of income, and the list of those things that are part of the economic damages well established in law across the states. But the non-economic damages are what are sometimes levered to send a message to the industry. And to make, a single person or a class of people very wealthy to send a message to the industry is very costly to our society and eventually to the taxpayers. So that's the reason.
Well, the American Bar Association says after 30 years of empirical research has shown that caps diminish access to the courts for low-wage earners, and a clear example of discrimination against women, as Mr. Cohen pointed out. I find it a little bit odd today that we have to change our gears and start saying states' rights are not that important. When we did the HACA, we heard repeatedly the power has to be returned to the states. So it's sort of a major change, actually, in your thinking.
Well, I would say, Ms. Slaughter, that if we're concerned about women being compensated less than men, with regard to this, which I heard in the gentleman from Tennessee's statement as well as your question, it would seem to me that this isn't the place to address it. It would be the place to address it in the workplace.
Well, I was addressing more the fact that on most of your life, I think you probably talked about states' rights.
Yes?
Suddenly now we're switching over to the federal government has that right. That was of concern to me.
And I appreciate you raising that point as well.
Particularly since the AHCA is particularly aimed at states' rights. And since this would be in contradiction of that, would it not?
This addresses, this protects all existing state laws that exist with regard to economic damages and does not interfere
it
with them
does?
at all. Yes.
The 5 states that have constitutional prohibitions on damage caps, they would be able to keep that?
Constitutional
They
provisions
are
on damage caps
Arizona,
for
Arkansas,
economic
Kentucky,
damages, yes.
Pennsylvania, Wyoming.
If they're,
They have-
if they're economic
Right.
damages, yes.
In New York and Oklahoma have state constitutional provisions on damage caps in case of wrongful death, including medical malpractice. In 11 states, Alabama, Florida, Georgia, Illinois, Missouri, New Hampshire, North Dakota, South Dakota, Utah, Washington, and Wisconsin, have state Supreme Courts that have struck down statutorily enacted medical malpractice damage caps. So this would not apply to those 16 states, I believe.
This would apply to all existing constitutional provisions and also statutory provisions for economic damages and preserve anything that exists within the states on those damages, but it would cap the non-economic damages at $250,000.
It's a very interesting concept. I have no further questions.
Chair would point out that under the 10th Amendment, states have powers, not rights. Under the 9th Amendment, people have rights. So when we use the word states' rights, we might want to use the term state powers.
State powers, okay.
Chair calls upon the gentleman from Georgia.
Just a clarification, Mr. Chairman. Because this has been a question, and Mr. King, I know, has been aware. Just ask another way, Georgia, of course, and several others have constitutional violation, which was passed in 2005 in Georgia, caps, that the Supreme Court said no, that there cannot be caps in Georgia under the Georgia Constitution. And your answer just a second ago, and I wanted to confirm what I said, what you're saying is that there would still be no caps in Georgia, or would this institute a $250,000 cap?
I have the piece that needed to be a more complete part of the answer to Ms. Slaughter is that states can pass a higher non-economic cap. They just have to have a statute that will do so. And you're saying that's in a constitutional?
Well, it was a constitutional, it was struck down in part of the med mal tort reform in Georgia in 2005. So I was just, and if, I see what you're saying, and I understand. I think I just wanted to make that clear because there was some confusion on it, and I know it came up in committee as well, so I just wanted to give you a chance to
Would the gentleman yield to
continue
me
that.
for a second? As I understand, you said that the state could do its own cap, but the things that I read were the cap itself
Yeah.
was found unconstitutional. So
That's
they
what- that's what I
couldn't
said.
do higher.
That's what, under state law, and that's what the question was
Right.
asked. So anyway, I yield back.
Thank you.
Gentleman yields back. Chair recognizes the gentleman from Massachusetts.
I mean, this kind of fits with the pattern. I mean, we have Trump Care that throws 25 million people off of health care and takes away essential benefits for regular people. Now we're going to punish people who have been injured, you know, and, in some sort of malpractice, which I think is, again, it fits the pattern here. But, Mr. King, you mentioned a number of times, you kept on invoking the California law, what it's actually called MICRA law, is how they refer to it. I just, for the record, would like to insert in the record, as unanimous consent, a statement from the American Association for Justice that basically says that H.R. 1215 is not MICRA, and they have a whole bunch of talking points here, which I'm happy to share with you, says that this is much worse for patients, what you're proposing. I'd also like to ask unanimous consent to insert in the record a letter that was sent to the leadership here in Congress of both parties from veteran services organizations strongly opposed to H.R. 1215. I'd like to also ask unanimous consent to insert in the record a letter signed by numerous groups, everything from labor groups to healthcare groups to consumer watchdog groups to organizations that advocate on the rights of individuals in nursing homes. I go on and on and on, who are very much opposed to this bill. Also, ask unanimous consent to insert to the record a letter from a number of very conservative organizations. I'm looking at these organizations. I mean, I probably get like a -20 rating with some of them, but maybe because I'm voting against you, my rating will go up to maybe -10. So that's probably a good thing. But this is not just progressive groups. There are other conservative groups that are opposed to this as well, some very well-known conservative groups. The National Conference of State Legislatures is opposed. The National Medical Malpractice Advocacy Association is opposed. The American Bar Association obviously opposed. The Consumers Union is opposed. Public Citizen is opposed. Center for Progressive Reform is opposed. I'd just like to, I think the record should include all of these strong letters of opposition, just so that it is clear that there's widespread opposition to this.
Without objection, so
And
ordered.
with that, I yield back my
Gentleman
time.
yields back. The gentleman from Washington is recognized.
Thank you, Mr. Chairman. By the way, you look good up there from the front of the dais. Mr. King, you listened to Mr. Cohen's comments, and I just wondered if you could respond to some of the things that he was saying, which would be, had to do with the states' rights issue that's come up a couple of times. As my reading of the bill is, if a state wants to pass a higher cap or lower cap, whatever they want to do, they can. Is that the
That is correct. And this bill, I think, is drafted carefully to walk around the states' rights issues and preserve states' rights issues.
Okay.
And it's an important component to me to be consistent with the 9th and 10th Amendment. And, when we look at the federal nexus and the language we used on federal nexus, that language is pretty clear. And I don't think there's any precedent out there that it's successfully or seriously even challenged a federal nexus on anything that's this clear. I mean, if we went to, I know Mr. Cohen would probably quote back to me in a different debate, Wicker v. Filburn, and the idea that the gentleman that was raising wheat and feeding it to his own hogs and eating his own meat was involved in interstate commerce, because if he hadn't done that, he would have had to buy the wheat from out of state. So this federal nexus is very clear, it's very solid, and I'm not concerned about it, but we did protect the states' rights in every way possible, and we have taxpayers' rights too to be concerned about. And they're not weighed against the constitutional provisions for states' rights because they don't conflict with each other. But protecting the taxpayers' rights is also important. And when we're looking at a $54 billion unnecessary expenditure that's dealing with medical malpractice and the hundreds of billions of dollars in unnecessary tests with a load of medical costs on us that's so great that the system is collapsing, and it's collapsing in Iowa itself. We have 94 of 99 counties have no individual health insurance market. Part of that is a function of this unnecessary litigation that's taking place, just part of it. We have a lot of pieces of this to fix. but this is a piece.
So keeping on that line of thought, if you can you relate to us some of the results of the reforms in California, some of the benefits that they've seen in that particular state, or Texas, or other states that have gone through the
Well,
same?
I didn't bring with me California results so much as just some narratives out of Texas that I related in my opening statement. But I would say that while I was giving that testimony, I received a call from the governor of Iowa that was ringing in my ears while I was testifying. And I expect that conversation is about what to do about getting a health insurance market for 94, 99 counties in Iowa. But Iowa did pass very similar legislation at the state level, and this has been picking up more and more interest around the country. They projected that the medical malpractice premiums would be cut by 50% and in Iowa. And one of the narratives that I told in my opening statement was of the anesthesiologists that had seen $26,000 a year premiums reduced to $6,500.
Texas.
In Texas, yes. And then one of the resistance that I think is kind of an undercurrent is Texas has an advantage right now in recruiting physicians, and they've been moving to Texas. Their health care is expanding in Texas, and I don't know what their costs are necessarily doing, but I expect that they are not accelerating at the rate as they are the rest of the country. And so it's going to be harder for Texas to recruit physicians if this bill becomes law. And I think that's part of a little bit of the resistance from Texans.
Well, that's one of the reasons that I think we're looking at doing this, is we're seeing a shortage of specialists in particular areas of medicine, largely or partly anyway, because of the increased costs of medical malpractice insurance. And if they're having success stories of recruiting in Texas because it's still more expensive in other states, then that maybe points to a good benefit of passing this legislation.
And I would point out also that the OBGYN will be a significant recipient, beneficiary of this policy. And I'm watching as I've had up my grandchildren, 1, 2, 3 of my 7 grandchildren were born in hospitals that no longer provide that service, and the oldest one's 12. It's happening all over my state, and I presume all over rural America. The OB coverage is being shut down in part because of high medical malpractice premiums. And so now that trip to the hospital for delivery is longer in many parts of the country, including my neighborhood.
Well, I just want to say thank you for bringing this bill forward, and thank Mr. Cohen also for providing your testimony. These are important topics that further our effort to try to make health care more affordable, more accessible to people in this country, to preserve those kinds of things that we heard were under threat. The original intent of Medicaid, we're trying to make sure that we do all we can to make sure that those low-income people, poor people, elderly people, those that need it most, have the care that they do need. And this is one step, as I think Dr. Burgess said, a step of 1,000 miles. But it's an important step, and I want to thank you for bringing this forward. And with that, Mr. Chairman, I'll yield back my time.
Thank you very much. Judge Hastings?
Thank you very much, Mr.
Yes, sir.
Chairman. Mr. King, California exempts nursing homes in their provision. Does your legislation do likewise?
There's no provision in this legislation to exempt nursing homes.
Do you think that's sound policy? You cite to California as the template or exemplar.
You know, Mr. Hastings, I hadn't contemplated that as far as measuring one against the other, but I'm open to counsel and advice on that suggestion.
Just for clarity, the exhibit that has been entered into the record that the chairman had us, what was the purpose of this? I didn't understand.
Okay. What this does is it compares the annual increase or potential decrease in medical expenditures against the healthcare workers' hourly earnings. And so the purpose in that, if you look at the chart, is that when healthcare costs go up, the medical expenditures go up, especially when it's dramatically, we see wages, the growth in wages doesn't keep track with that. It stays flat or potentially could go even.
Well, the one thing that was concerning to me is your chart ends in 2006. So what has happened since 2006?
Well, You know, if I knew the answer to that, I would be happy to answer the question, Mr. Hastings.
Well,
I
I'll
don't
just
know the
take it-
answer to that, and
I'll
I
take
asked that
it
same question
for
myself.
advisement, but, it's a neat chart.
probably the end of the
but
study.
A whole lot of things have happened with wages and with other concerns and expenditures.
But I would
Gentlemen,
point out
Yes, I
that
will.
Would the
1980
gentleman believe it would be a good question simply because, not just because I think it would be, but you'd accept that you would ask the gentleman if he could put the source of this and provide an update to it for the record? It might be more meaningful.
That would be helpful,
As a
Mr.
matter
Chairman.
of fact, yes, I
Yeah.
dug through that myself.
That would
and-
be helpful, but it
Thank you very much.
still won't add the 11 years of data that could.
Well, no, sir, what I'm suggesting
Yeah.
is if you updated the source and the year.
All right, all right.
I'm asking really to help
That would be fine with
clarify
me.
your opportunity. Thank you
All
very
right,
much.
fine with me. I do have one additional question, and I'd like to read to you, Mr. King,
Uh-huh.
that, as Ms. Slaughter pointed out, there are 5 states that have state constitutional prohibitions. 2 states, including New York and Oklahoma, that have state constitutional prohibitions on damage caps in cases of wrongful death, including medical malpractice. And then 11 states, my state, Florida, included.
Okay.
All right.
And
The Florida Supreme Court ruled that a state law capping non-economic damages in wrongful death cases violates the state's constitution's equal protection clause. And Florida passed the law to address an alleged medical malpractice insurance crisis, but the court found that such a crisis never materialized, and that the law is arbitrary and bears no rational relationship to its stated purpose. And the cite is from several cases that the Florida Supreme Court established this particular precedent. Now, this legislation that you offer, does it preempt what Florida has done or what these other 21 states, 19 states have done with reference to their constitutional provision? How do you reconcile the equal protection clause with this particular measure?
Well, Mr. Hastings, where a state court has acted, I'm advised from Constitutional Counsel that then essentially the state is powerless to reverse that case, and it would require an act of Congress to do so. And so if those issues
then you
become,
would be preempting.
I don't believe this
states' rights.
legislation preempts those Supreme Court decisions. It would take an act of Congress to do so.
And that's what you're attempting to do?
Not under this legislation. I
All
believe
right.
this, that the decisions of the state Supreme Court will stand unless Congress should intercede. And if I might add too, I knew I looked up this chart origin. It's the Journal of American Medical Association.
Yeah.
So
Fine, Mr. Cohen?
Mr. Hastings, I believe you're correct that if there's a state, if there's no damages, no limitations by Constitution or by a Supreme Court case, then this would put a damage limitation on them of $250. That would put a cap. It only limits where there is already a monetary
That's right.
limit. And if there's no monetary limit by either Florida, the Supreme Court, or there's, I think, 5 states who have in their Constitution, because you have a right to trial or do however you want to look at it, then it would preempt them. The National Conference of State Legislatures wrote a letter. Mr. Newhouse, I think you'll find this enlightening. Mr. Newhouse, the National Conference of State Legislatures came out and said that this is rife with preemption, federal preemption, notwithstanding the state flexibility language riddled throughout the bill. This language is deceptive and only grants flexibility to states with more restrictive provisions. For example, all states have established statute of limitations for medical malpractice. The federally mandated statute of limitations 3 years after the date of entry or 1 year after the discovery. More stringent limitations of minor child would preempt approximately 47 states. H.R. 1215's requirement, the imposition of several liability based on percentage of fault would unjustly preempt 26 jurisdictions. And despite state flexibility, proposed non-economic damage cap would automatically preempts 17 jurisdictions which do not have a damage limit award or cap and jeopardize some of the 35 other states. The state of Alabama, Arizona, Arkansas, Georgia, New Hampshire are 5 states in particular which would be affected. NCSL is 100% against this and never had an opportunity to testify and voice their objections because it went straight, without any hearings, it went straight to markup and then went straight to the floor in 4 days.
I might add, Mr. Cohen, that has been, and I associate myself with the remarks of Mr. McGovern, that's been entered by unanimous consent into the record of that particular measure.
Without objection, I'll add that.
Thank you very much, Mr. Chairman. You know, as a lawyer of 51 years, I learned something along the way that, first off, very few physicians enter into any relationship with a patient with the thought in mind of harming a person. That said, generally, it's de minimis that the tests are run, and all of the data seems to reflect that nearly 2% of the added increases that physicians allow for their patients in terms of added tests, it's minor by comparison. What I found over the years, and I didn't have any major medical malpractice case, but what I found, and I would talk with lawyers and physicians about, is that the bandits in this case were the insurance companies, and they were not the lawyers, and they were not the physicians. There were only a handful of large verdicts that were rendered. And the objective here seems to be to go after those who can't access the system, and add to that product liability and all of the attendant features of joint and several liability being avoided. I think it harms access to justice, and toward that end, I would be very much opposed to this legislation. I yield back, Mr. Chairman.
Judge, thank you very much. Ladies and gentlemen, we are now right on the last minute of being able to vote. I would ask not only both of our important witnesses, please come back, but also the committee to do so. And those who wish to testify will come back immediately after the last vote. So subject called chair will come back immediately after the last vote. That's a great line.
Yeah, absolutely. This is a great.
Love that. Committee will come back into order, and thank you very much for allowing the day of the votes on the floor. We'll now continue with the continuation of the hearing, H.R. 1215, Protecting Access to Care Act of 2017. I would, if I could, remind not only our committee, but all the people who are here that the ability to hear in the room is skewed a bit as we have a full committee room with people in it, and our stenographer has the job of trying to make sure she hears not only the conversations that take place between the committee and the witnesses, but also the witnesses to us, and sometimes it's not as easy for her to hear as our acoustics in the room might interfere with that. So I would say thank you very much, and I would remind that gentlewoman, if she is having problems, just to yell or scream at Judge Hastings, and he will make sure that we, because you're kind of in that same area there, you see it as it comes over of the impact on her. Thank you very much.
Excuse me, I didn't hear that. Would you repeat that?
Yes, sir. What I said is that Stephen Cohen, who is from Tennessee, is a fine young man, and that we're delighted that he is here. And Mr. Cohen, I do want to thank you and Mr. King from Iowa, not only for your attendance, but also working through this committee with the questions that it has, with not only the deliberate action that you've got, but the thoughtful consideration to the members who are trying to ask questions. I appreciate you very much. Judge Hastings, did you have an opportunity to ask all the questions, or did we rush you in any way? So the gentleman, in fact, has taken the time that he needed and would yield back that time. Thank you very much. We would then ask any other member of the committee if they have questions. Mr. Buck, do you have any questions of this panel? The gentleman from Windsor, Colorado does not seek time. Thank you very much. Gentlemen, I want to thank you very much. Before I let you go, I just want to add my bit of words, whether it's wisdom or not, might be based upon your own judgment. But Texas, of which I am a resident and a Texan, went through their own state process, medical malpractice. And as a result of the ability that we undertook against really enormous odds, meant that in the first year immediately after, we added some 4,600 doctors who then came to the state of Texas. It is, if you were in business and trying to help people, if you'd committed yourself as a physician to not only, as Judge Hastings says, caring about every patient, because I don't think doctors start by trying to harm anybody, but the threat is larger than the actual ability to protect them. And we found in Texas that when we followed a process that was based on the law in California that's called MACRA, when we entitled ourselves to that full debate, it has come out as being a very successful balance. And I have reminded our, albeit whether it be insurance companies or others, health providers or doctors, I've told them that it's a balance that must be preserved, and that is when a mistake legitimately is made, and they are made, that they should not fight that necessarily in a negative way just because the law might be on their side. That patients or those that were harmed would stand a chance to receive the benefit of the tort law. So I want to thank both of you for being here. I would say after looking at this in Texas for a number of years, we consider it a very favorable, positive attribute that's a balance on beside of not only patients, but also physicians that have gathered together the help that we needed. Last point, we were having problems in many areas of Texas where actually lawsuits kept certain doctors, as the gentleman, Mr. King, suggested, certain types of physicians that provide certain types of support. But the biggest one was actually where we had trauma one level centers where people would be saved off of a highway, flown in critical condition, and a thoracic surgeon or another surgeon might actually save somebody's life only to find out that they were sued for something that they did not completely see or correct in the midst of saving somebody's life. And it became an impediment to people wanting to do the right thing and to take tough cases. Tough cases are hard, and it happens in all areas of practice. And this empowers people to know that if they follow a standard of care as they perform their duties, that in fact there are provisions that will allow them to be protected under the law, even when there are things that go wrong. So I'd like for us to think about this as a balance between protecting a physician who is there to try and help the patient, but willing to take on a tough case, but also willing to take on a case knowing that if they do the right thing, even if the wrong thing might occur, unbeknownst to them, that there's some level of protection. So I want to thank both of you, and thank you for listening to me about my thoughts and ideas about this. Mr. Cohen, as always, you've done well enough to get invited back. I look forward to you doing so, and I'm sure you'll be on the floor. Mr. King, thank you for not only your presentation today, but your words of confidence about the bill, which you so ably support. Thank you very much. Thank you, Mr. Chairman. Yes, sir. The committee will now move to panel number 2. I note that there are a number of members who have not only sought the ability to come forth, and some are here and some are not here yet. I know the gentleman from Kentucky, Mr. Barr, had not only been seated at the table for quite some time. We will include him on this panel if he arrives. The gentleman from North Carolina, the new young father from North Carolina, Mr. Hudson, thank you for joining us. The gentleman, Mr. Rowe, Dr. Rowe, evidently had sought time. Perhaps he will be here, perhaps he won't. The gentleman, Dr. Bouchon from Indiana, if the gentleman would seek time as the panel, that's his business. And seeing that Mr. Barr is not here yet, we will go ahead and pursue this. I note that there were 2 members of the Democratic Party who had indicated that they would seek time. I do not see them. Just so we know, when they walk in, we will, up to the time we end the hearing, we will, it would be the 2 of your favorite members. And so we will allow them if they appear, and if they don't appear, then we will move on. Yes, ma'am. Mr. Hudson, we're delighted that you're here. The gentleman has the amendment before the committee. The gentleman is now recognized without objection. Anything the gentleman has in writing will be entered the record, and the gentleman will leave that for the clerk, the awesome stenographer who's able to complete the record. The gentleman's recognized.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. It's an honor to be here before you. I'd like to thank Dr. Larry Bouchon, who's agreed to appear here with me in case there are some detailed questions that only a
you're
provider
after
might
expert
answer.
witness.
Yes, that's correct. That's correct. And I've got, I had 4 amendments, but I've been asked to combine them into one for the purpose of time, which I'm pleased to do. And so, basically for me, what this whole debate comes down to is a fair and just judicial system is the key to our American system here in this country, but it's important that courts are used to seek justice, not for financial benefit of predatory trial lawyers looking to take advantage of patients. And the basic protections this amendment that I'm offering provides for frivolous lawsuits will provide peace of mind for the vast majority of our providers and physicians who work so hard to protect and heal their patients. Patients in states that have enacted comprehensive medical liability reform have seen their health care costs decrease and their access to quality medical care increase. Enacting these reforms at the federal level will benefit patients nationwide. There's 4 provisions. The first provision is called the SORRY provision, and this provision would allow a physician to apologize to a patient for an unintended outcome without having that apology count against them in the court of law. It defers to state laws that directly address the same issues covered in the bill. There are 32 states plus the District of Columbia that already have an apology provision in place. The second provision is a notice of intent. This provision would require a plaintiff to provide a notice of intent to the physician 90 days before a lawsuit is filed. Cases are often settled before reaching a verdict, and this provision would encourage settlement before court proceedings begin. It defers to state laws that directly address the same issues covered in the bill. The third provision is the affidavit of merit. This provision would require a plaintiff to have a physician in the same specialty as the defendant physician sign an affidavit certifying the merits of the case before a lawsuit could be brought to court. Again, we defer to state law that directly address the same issues covered in the bill. 27 states have some form of affidavit of merit requirement, though the standards vary from state to state. The final provision is expert witness qualification. This provision would require that any expert witness called to testify during a trial, the witness would need to meet the same licensing requirements as the defendant physician. Again, we defer to state laws that directly address the same issues covered in the bill. 48 states plus the District of Columbia have some form of expert witness qualification, though the standards do vary state to state. So with that, Mr. Chairman, I will conclude and look forward to any questions the committee may have or any statement that Mr. Bashan would like to make.
Just here to answer questions.
Dr. Bashan, you are an expert witness. We haven't sworn you in that way yet, but the gentleman served as a medical professional and doctor for a number of years, and I thank you very much for not only being here, but being here to answer questions that may pertain to these amendments, and thank you very much.
You're welcome, Mr. Chairman.
The gentleman from Oklahoma, the young chairman. I have no questions. The gentleman does not seek time. Mrs. Slaughter?
No questions, thank you.
Is there any other member of the panel on the Democrat side that would have a question for the panel? Seeing none, thank you very much. Is there any member of the majority that would seek time with the gentleman or the expert witness who's been provided, the gentleman, Dr. Bashan? Seeing none, thank you very much. Gentlemen, thank you very much. I will tell you,
Thank you.
I do appreciate you, Dr. Bashan, taking time. I think that the issue that we're dealing with is most imperative to understand some of the intricacies that you see from the medical profession also, and I want to thank you for taking time. As always, the gentleman approached me a couple weeks ago and advised me that he would be providing these amendments, and I appreciate his confidence to move those 4-1, and I appreciate it very much. If you'll please make sure anything you brought in writing will be left for Austin stenographer, I appreciate it. Thank you very much. This now moves us to the point where I need to ask if there's any other member that would seek to give testimony in the matter of H.R. 1215, Protecting Access to Care Act of 2017. It's my understanding that a gentleman who had sought our time, I told him we would be coming in, and the gentleman from Kentucky had spoken to me about his desire to not only be here, but to provide testimony therein. The gentleman, Mr. Barr, has presented 2 amendments to the committee. These 2 amendments deal with matters of substance that he believed would be important not only to be discussed, but also information to be shared. I will yield myself such time as I may consume for speaking about amendment number 24, which is offered by myself. Several weeks ago, the Texas Medical Association, which is the professional organization that represents medical professionals and doctors in Texas, wrote members of Congress from Texas seeking not only feedback, but also information about their concerns that they had about this bill, H.R. 1215. My staff, including myself, looked at the letter and tried to dissect their concerns. In an effort to speak to the Texas Medical Association, I sent them a letter. They have now responded back, where they have moved themselves from having a problem with the bill to being in support of the bill. And I would like to add this letter to the record, which is from the Texas Medical Association, and I would read this matter that these amendments will align the federal bill with Texas law and help protect our Texas landmark legislation, which has improved patient access and brought a record number of new doctors to the state of Texas. That is in this letter dated June 12th, 2017. So without objection, I will enter that into the record, a letter from the Texas Medical Association, and I want to thank the Texas Medical Association for providing that. We've now used up enough, consumed enough time where the gentleman from Kentucky has had a chance to appear before the committee, and Congressman Barr, we recognize that you were here for a long time. We recognize that there was a vote and that you did come and speak with me and ask that you be allowed variance of a few minutes. That time has now appeared, and such has the gentleman also. So without objection, anything gentleman has in writing will be entered in the record. The gentleman from Kentucky, the distinguished gentleman, Mr. Barr, is now recognized.
Thank you, Mr. Chairman, Ranking Member Slaughter, members of the Rules Committee. I appreciate the opportunity to offer these two amendments. And I would like to first commend Chairman Goodlatte and Congressman King and others who worked on H.R. 1215, the Protecting Access to Care Act, which aims to address the real problem of junk lawsuits in the context of medical care. These frivolous claims indeed drive up the cost of health care. They encourage defensive medicine and contribute to the nation's severe shortage of doctors and nurses, especially in high-risk areas such as neurosurgery, obstetrics, and emergency medicine. So we do need to enact sensible medical malpractice reform, and given the clear federal interest in reducing taxpayer costs wherever federal policy affects the distribution of health care, I support H.R. 1215. But it is in that spirit that I offer this amendment, which I believe would improve the legislation and address lingering concerns about the legislation's failure to fully respect the principles of federalism. It is true that the authors of the bill took care to make sure the bill only applies to claims concerning the provision of goods or services for which coverage is provided in whole or in part via a federal program, subsidy, or tax benefit, giving it a clear federal nexus. In addition, the bill does not preempt any state laws that cap damages at different amounts or any state laws that provide greater protection for healthcare providers in the specific areas covered by the bill. However, there remain legitimate concerns that this bill improperly imposes federal requirements on state courts in cases involving exclusively state law claims. Common law negligence, the kind of claim brought in a medical malpractice case, is traditionally and exclusively a creature of state law. And this bill seeks to regulate the way in which state courts conduct state-based litigation. Credible legal authority suggests that Congress lacks the constitutional power to regulate the procedures by which state courts adjudicate claims arising under state law. As one legal scholar has said, exclusive state control of state court enforcement of state law rights serves the traditional normative values of federalism. That's the Yale Law Journal. State courts may and routinely do entertain federal claims and enforce federal law. But when there are no federal legal issues implicated, traditional principles of federalism and the 10th Amendment limit Congress's power over state courts. And this is precisely the point that I think addresses the exchange between Ranking Member Slaughter and Congressman Collins earlier when they raised the issue of state constitutional jural rights. Kentucky, from which I hail, is one of those states, Congresswoman Slaughter, that you cited. So what we're trying to do in this amendment is solve this problem and the problem that was raised by the National Council of State Legislatures, quoted and cited by Congressman Cohen. It is true that over the last century, the Supreme Court has expansively interpreted the commerce power, dramatically curtailing those matters exclusively within the jurisdiction of states. However, in United States versus New York in 1992, the Supreme Court limited Congress's power to commandeer state legislatures to enforce federal law. And in United States versus Prince, 1997, the Supreme Court struck down Congress's attempt to commandeer state executives to enforce federal law. As the majority decision in New York reasoned, states are not mere political subdivisions of the United States. State governments are neither regional offices nor administrative agencies of the federal government. The Constitution instead leaves the several states as a residuary and inviolable sovereignty. That's from Federalist number 39. So the question before us today is the extent to which Congress has the power to commandeer a state judiciary to enforce federal law. My amendment, drawn from the architecture of a bipartisan bill that I introduced with Congressman Cuellar, removes all doubt about the constitutionality of this much-needed legislation. By explicitly creating a right of removal to federal court, this amendment limits enforcement of these new statutory curbs on malpractice claims to federal courts, eliminating entirely the constitutional concern about federal interference with state courts adjudicating purely state law claims. And with that, Mr. Chairman, I'll yield back on that amendment, or if you'd like me to proceed with the second amendment, I can do that.
The gentleman has requested to please move forward on his second amendment that the gentleman is offering to the committee.
Thank you, Mr. Chairman. The second amendment that I offer for the Rules Committee's consideration also reflects the spirit in which I offered the first. And again, want to commend the authors of this much-needed legislation, Chairman Goodlatte and Congressman King, who did a fantastic job in putting H.R. 1215 together, which I think aims to address this real problem, this legitimate problem of junk lawsuits. And I do support that legislation given the clear federal interest, again, in reducing taxpayer costs wherever there is a federal payer. But H.R. 1215 in its current form attempts to address a lot of these issues by imposing caps on non-economic damages. And that's a positive, certainly from the standpoint of the CBO, which has found that that would reduce healthcare costs to taxpayers and premium payers. However, and respectfully, H.R. 1215 does not go far enough to get at the core issue. The core issue is not as much non-economic damages. The core issue is defensive medicine. That's what truly drives up the cost of care and results in higher cost to taxpayers and higher cost to premium payers. And so when we talk about defensive medicine, we're talking about the administration of health services, tests, and procedures designed to shield the provider from legal liability, but which may not be medically indicated, which may not be medically necessary or in the best interest of the patient. Defensive medicine is a major driver of healthcare costs, and it also, in many cases, reduces the quality of patient care. So in that spirit, I offer this amendment, which would expand upon the reforms in H.R. 1215 to protect physicians and other healthcare providers from frivolous lawsuits while promoting the practice of evidence-based medicine to lower costs and improve healthcare quality. My amendment would offer a legal safe harbor in the form of an affirmative defense for defendants who can show that they adhered to clinical practice guidelines in their area of medical practice. Rather than Washington-directed, Washington-based healthcare, the guidelines would be developed by the physician community based on best available scientific evidence. This would allow doctors to focus on practicing medicine rather than litigation avoidance. It would also improve healthcare quality by encouraging the practice of evidence-based, peer-reviewed medicine as opposed to defensive medicine. A New England Journal of Medicine study on clinical practice guidelines and tort reform stated that, quote, safe harbor rules hold promise for realigning legal incentives with good medical practice and promoting fast uptake of proven modes of care, unquote. By promoting adherence to clinical practice guidelines that are already maintained by medical specialty groups, this amendment would encourage physicians to provide higher quality care while at the same time reducing medical errors and waste. Over 13 states already have safe harbor legislation in place that have significantly lowered the length and costs associated with medical malpractice cases. This amendment would build on the success of state safe harbor laws by expanding it to a national level while not infringing on states' ability to implement additional tort reform. Mr. Chairman, Americans deserve healthcare reform that will help lower the cost of care and protect the sacred patient-doctor relationship. The current reforms within H.R. 1215 are an important first step to reducing the high cost of medical malpractice claims. These amendments will further strengthen this legislation to promote affordable, evidence-based patient care, reduce defensive medicine, and allow healthcare professionals to focus on actual patient needs. Thank you, Mr. Chairman, and I yield back the balance of my time and be available for any questions.
Mr. Barr, thank you very much. Mr. Barr, notwithstanding, I know this is not your bill. I know that you have read the bill. I know that you serve within the jurisdictional elements of lots of these issues, but you have brought up an amendment that perhaps strikes at the heart of some of the argument that you would speak about. And my question to you is, the people who were bringing the bill forth, in my opinion, have brought this forth on behalf of, let's say, ideas about reducing cost. The cost could also be subscribed directly to the federal government, and that the federal government would have an interest in these matters, even though that you would maintain they lie within the state jurisdictional models. Is the evidence that the federal government is a payor or a payee in these circumstances enough evidence to you that that's why you think this methodology is being done? In other words, the Lexis, the Nexus, the germaneness test of the application?
Yes, sir.
Can you describe what you think might be a reasonable person who would think that?
Yes, absolutely, and I commend Chairman Goodlatte and I commend Congressman King for recognizing the importance of, as a trigger, as a prerequisite to the federal reforms that we're proposing here, that there be a federal nexus, namely that there be some federal statute or some federal payer involved. And so I commend the committee and the authors of the bill for recognizing that. The First Amendment that I offered, however, does attempt to address a lingering argument that you may have heard a little bit earlier, and that relates to this idea, maybe it's a theory, but maybe it's a legitimate argument, that the bill that is, the underlying bill proposes to impose federal procedural requirements on state courts involving matters that are exclusively within the jurisdiction of state law, namely tort law. So because we're imposing caps, this bill would impose caps on damages to a state law claim in a state court. And that could be interpreted as a imposing or federal regulation of a state court in a matter relating exclusively to state law.
And so thus you would then say that's why under the circumstances it would be prescribed for the remediation to be done in federal court.
Yeah, so the amendment that I'm offering would completely take away any possible argument that this legislation violates state constitutional juror rights. It would completely take away any argument offered by anyone that we are violating federalism, that we're commandeering state judiciaries, and because clearly the Congress has plenary authority to regulate federal procedures in federal court. And I do believe there is a federal nexus here, and I think that the authors of the bill are to be commended for making sure that that is a prerequisite to the cases we're talking about, but there's still an argument that there is an imposition of federal procedure on state courts that could be violative, at least, of the spirit of federalism.
I get that one. Thank you very much. Chairman Cole? No question. Chairman Cole does not seek time. The gentlewoman from New York.
Well, I want to support my fellow Kentuckian here, although I don't sound like it anymore, do I? Listen, on your First Amendment, I think that would be litigated till the cows come home. I don't see any way in the world to interpret that, but we are usurping the state power. We would be forcing them and their constitutions to say they are not accurate. I don't believe you can cure that bill. Seriously, it's. Sometimes I wonder where they come from. I picture somebody down in a basement in a windowless room being forced to write 4 or 5 of these a day that don't have to go through committees, that can just come up here and name them something that's very beneficial, like the bill to cure all cancer, something like that. So if you vote against that, you know, you're in trouble. So anyway, I don't care for that one. Second one, you're absolutely right. Defensive medicine is really a culprit here. I think there are hospitals that if you went in with a broken toe, you'd have to have a chest x-ray. And I do believe that what we did in New York, and I don't know if it's one of your safe haven states, but when I was there, we did a lot of work on insurance, and we defined what a frivolous lawsuit was, and a person bringing one or a group bringing one was penalized heavily for it when it lost. And I have to review it and see if it's still in effect. It's quite a while since I was there. But I think you're on the right street for that. I do believe that that's something very necessary.
Thank you.
I yield
Thank you,
back. Thank you.
Chairwoman Yelsbacher. Time. By the way, she does very well up here when she brings rhubarb pie. So,
I did. I brought
ne- ne-
rhubarb pie, and it was just, I could keep them quiet for about a month. And then it's all over.
Well, you're welcome to bring that pie.
So just so you know, Congressman Barr, next time she does that, she brought 3 of them, and all 3 were gone by the time I left the room. So we'll invite you next time, but she makes a mean pie.
You're always welcome to come home and bring that pie back home to Kentucky.
What I'd give anything for is if I could buy a white cornmeal up in New York State, New York. That would really be a treat.
Thank you.
Yeah. Does the gentleman from Massachusetts seek time with the gentleman from Kentucky? Gentleman does not seek time. Judge? Gentleman's recognized.
To include in the record the statement of our colleague, Congresswoman Sheila Jackson Lee of Texas, which I wish everybody had an opportunity to read it. I found it particularly poignant on the restrictive aspect of Texas law as it pertains to malpractice. In addition, Mr. Chairman, I guess it's out of habit, but I'd like very much to ask unanimous consent to include the statement of administration policy.
Without objection, we'll include the
We'll
staff.
make sure that it gets in the record. Additionally, I would urge that Mr. Barr's amendments be made in order. I think particularly the first one would remedy some of the concerns that some of us have, and I think it was very thoughtful of him, and I would urge that his amendments be made in order. Thank you, Mr. Chairman.
Judge, thank you very much. Gentleman yields back his time. For the purposes of the committee, the Statement of Administrative Policy dated June 13, 2017, H.R. 2015. At the end, it says, if H.R. 1215 were presented to the President, his senior advisors would recommend that he sign the bill into law. Thank you very much. Is there any other member of the committee that would seek time? The gentleman from Louisville, Texas, Dr. Michael Burke.
Thank you, Mr. Chairman. Let me just ask for the purposes of clarification in my own mind, if that federal nexus or federal payer, would that apply to the EMTALA laws that govern our emergency room doctors being required to see and stabilize a patient within 30 minutes? I mean, that's federal law, so that any patient who comes in, although they may not be a Medicare, Medicaid patient, would be covered under EMTALA, so that would be the federal nexus. Would that be included in your amendment?
On the underlying bill, I won't want to speak for Congressman King, but I believe that was, as I read it, that's its intent. It's certainly my intent with the amendment that I'm offering. And certainly if there was a malpractice claim arising under the rendition of health care mandated by EMTALA, there is a federal nexus. And I believe that the federal Congress could impose tort reforms or regulations of federal court that would entertain that claim upon removal. So yes, the bottom line is there is a federal nexus there.
So this has been one of the big frustrations that you hear from emergency room doctors, and I covered emergency rooms during some of my years in clinical practice, that you're at risk for, you have no control over what comes through the back door of a hospital's emergency department. And by virtue of federal law, of course, you're obligated to see and stabilize every patient who comes in the door, or arrange for transfer to an appropriate facility, which is, while it may be the right thing to do, is extremely burdensome and is one of the things that tends to limit a physician's wish to continue in clinical practice. If I've got to continue to take emergency call, it may not be worth it because of the liability that I might incur under EMTALA. So this is I appreciate what you've brought to us, and I think that is an important aspect of the overall legislation that we're considering.
And I would just add to that, that in the conversations that I've had with healthcare workers in emergency rooms, whether they're nurses or physicians, that there's a shortage of healthcare providers in that setting, and to the extent we can limit their exposure to frivolous claims, frivolous lawsuits, I think we help remedy that shortage of physicians and nurses in the emergency room. And that's good for patients.
Thank you, Mr. Chairman. I'll yield back.
Very interesting questions. Thank you very much. The gentleman from Georgia, Mr. Collins, is recognized.
Thank you, Mr. Chairman. Mine just sort of, I appreciate the gentleman. He and I have talked about this issue on multiple fronts and multiple occasions. I appreciate the amendments and the discussion that goes behind it. I think this is a very valid discussion. It's a very valid issue that does show promise. I think this helps, and I think the discussion is as we go forward. And I just want to say, to the representative that like I said, I appreciate his persistence on this because it's something you've not let go of and you found a way to do it. This is what I encourage more members to do, is find ways to express, good ideas that they have, and I appreciate it. We have to get back.
Thank you.
Thank you very much. The gentleman from Washington does not seek time. The gentleman from Windsor, Colorado does not seek time. Thank you very much. Mr. Barr, your not only instructive words and wisdom, but also your professional guidance and demeanor helps us, and we appreciate you taking time
Thank you, Mr.
to
Chairman.
be before the committee. It's my hope that you'll leave whatever you brought in writing for an awesome stenographer.
Thank you very much.
Thank the gentleman
I
very
appreciate
much.
the gentleman.
Is there any other member that would seek time before the committee? Any other member that seek time for the committee to give testimony of H.R. 1215? Seeing none, this now closes the hearing portion of H.R. 1215. Excuse me just a moment. Before I close that, I have a statement on the record. The gentleman that I believe he had submitted, the gentleman, Mr. Hudson, but I need to make sure that that was done, and I think that was it. So we'll just make sure that that is there. So this closes the hearing portion. The chairman now being in receipt of a motion from the gentleman, the young chairman from Oklahoma.
Mr. Chairman, I move the committee grant H.R. 1215, the Protecting Access to Care Act of 2017, a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and the ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for purpose of amendment, an amendment in the nature of a substitute, consisting of the text of Rules Committee Print 115-10, and provides that it shall be considered as read. The rule waives all points of order against the amendment in the nature of a substitute. The rule makes an order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, and shall not be subject to demand for division of the question. The rule waives all points of order against the amendments printed in the report. Finally, the rule provides one motion to recommit with or without instructions.
Thank you very much. You've now heard the motion from the gentleman from Oklahoma. Is there amendment or discussion to that?
Yes, Mr.
Gentlewoman
Chairman.
from New York.
Thank you. I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment to H.R. 1215 by Representative Raskin, number 14, which would preclude this bill from preempting state law permitting the use of joint and several liability and medical malpractice actions.
Thank you very much. Further discussion?
You can spare us one, can't you?
There you go. We will spare the discussion then and move forward to the vote. Those in favor of the slaughter amendment signify by saying aye.
Aye.
Those opposed, no.
Oh,
Noes have it, noes have it.
I just want.
I know. Some years are like this.
Some decades.
Decades are like this.
Okay.
Is there any other amendment or discussion? Seeing none, the vote now.
Yeah, I'm sorry.
The gentleman from Massachusetts
I have an
recognized.
amendment to the rule. I move the committee grant H.R. 1215 an open rule so that all members have the opportunity to offer amendments to the bill on the floor.
Thank you very much. Discussion. The vote now be on the amendment from the gentleman from Massachusetts. Those in favor signify by saying aye.
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 Those opposed, no. Noes have it, noes have it.
As for roll call.
Gentleman asks for a roll call vote. Clerk will poll the committee.
Mr. Cole? Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Newhouse? Mr. Newhouse, no. Mr. Buck? Mr. Buck, no. Ms. Cheney? Ms. Slaughter?
Yes.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Aye. Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 7 nays.
The amendment's not agreed to, and we'll move forward. Oh, that was on the motion.
Yes. We have
That was
to
on the
vote for
motion, so
this.
the motion. Oh, the government amendment, excuse me.
It was an amendment.
We'll now move to the, is there further amendment or discussion?
Yes,
Gentleman
discussion,
from
Mr.
Massachusetts,
Chairman.
Gentleman from
I
Florida.
just want to keep a running record, Mr. Chairman, in light of how this session began, and the Speaker of the House of Representatives' admonition that we would return to regular order and that we would be open. The rules providing for a measure, there have been 60 of them in this session of Congress. Open, 0. Modified open, 0. Structured, including this one today, 24 or 40% of all of what we have done. Closed, 36 or 60%. We're on track to have a record number of closed rules if we continue. We've had 33 measures and hearings or rules. If we keep up this pace, we'll have a record number. And it certainly puts the lie to openness in this process. And I'm going to continue as we go along periodically to remind us of the critical need that we have in this institution to get back to regular order. Thank you, Mr. Chairman.
I think we were misinformed.
Over and over.
Mr. Chairman?
I want to thank the gentleman for his comments and do wish to address them. Thank you very much. The gentleman seeks time.
I have always shared the concerns that my friend from Florida has raised. My concern is that we rarely discuss it in an effort to make a difference. We usually discuss it in an effort to make a point. For example, as my friend from Florida knows, almost the majority of those closed rules were either Congressional Review Act provisions, which have to come under a closed rule to be considered, or they were bills for which absolutely no amendments were offered, and thus we offered a closed rule.
That's not true on the Congressional Reform Act. They don't have to become, there's no requirement that they come up under a closed rule.
In order to qualify, claim my time, in order to qualify under the Congressional Review Act procedures, they can only be used for a limited purpose. So all someone needs to do is go down and have an amendment that I think we should pay veterans more money, and we all agree that we should pay veterans more money, which violates the use of the provision. But
We got to get a tutorial on the rules because we have a different interpretation of how those could have been brought to the floor.
But to my friend's point, when there are times that I know that we all want to be better, and I see my chairman work hard to do better in those times. I hope that we can find a pathway forward better together. I know that when you all closed down the process, when I was a staffer here, it was the explanation was the minority was abusing the process, and we just can't have an open process with an intransigent minority.
Mr. Woodall, we didn't say that.
Oh,
We would say that
be,
that we had to close it down because we didn't want a new process. Process is what we're asking for here.
reclaiming my time, the gentlelady remembers it better than I do because she was the chairman of this
don't.
committee and implemented those policies when we stopped for the first time in my lifetime having open rules on appropriations bills. That was the gentlelady's committee that did that, and it was done. I certainly was not casting any aspersions. I was saying that the statements were, if we had a cooperative minority, we could continue free and open debate, but we don't have a cooperative minority, and so we can't. I'm not even disputing that. I'm happy to have you say that that's not the case. I wasn't even disputing that that was the case. What I am disputing is that what you see here is the reflection of a more closed process. What I see here is a very real and sincere effort to open up the process, and what the chairman has some things he can do, and the chairman has some things he can't do. And if we are to make a difference in this process, we're going to have to focus ourselves on those times where we know that we can do better together, and we're also going to have to recognize those times where we know that we can't. I will note that when my friend Mr. Walls came here yesterday and asked for a closed rule because he knew that the only way we were going to be able to get veterans served, that's going to go on the list. The most sincere members of our collective conferences will show up in front of this committee, tell you the only way we're going to get our constituents served because of the way this particular measure had to be balanced is to bring under a closed rule, and then we will talk about it as if the chairman and somehow sold openness down the river in order to move a partisan agenda, which is nonsense, as
When
we
my
all
colleague
know.
finishes, would you yield?
I'd be happy to yield, my friend.
Then are you saying that I'm not in order to bring it under our discussion?
Oh, no.
measure?
Reclaiming my time, please don't let me leave
All
with
right.
that impression. No, Mr.
All
Casey.
right, then, if the gentleman
Happy to yield.
would continue to yield, under the structured rule that we are here on today, there were at least 2 Democratic amendments, and none of them were made in order. And let me make it very clear to you, I have great respect for our chairman, and I have great respect for the chairman doing everything he can to open the process. But all of us, we're not rookies here, including the couple of rookies. They know what's going on here. They've had a considerable amount of experience. And so toward that end, I'm arguing, and let's use the one that Dr. Rowe and Tim Waltz brought here. It was to their way of going about business that it had to be closed. It didn't have to be closed. We could have opened it up, and there would have been amendments that could have been offered by any number of individuals in the institution. So toward that end, I appreciate the gentleman yielding to me. All right?
I want to associate myself with the gentleman's concern over a more closed process rather than a more open process. My point is only that as I have that conversation with my colleagues, there are paths to get there that are easier and paths to get there that are harder. The path that is harder is the one that describes it as some sort of partisan edge designed to shut out a disenfranchised minority. The path that is easier is the one that says, there are lots of legitimate reasons why it happened this way, but here are 2 or 3 or 4 examples where we could have done better, and why didn't we? Why didn't we do better? I want to ask those questions too when we have an opportunity to do better. Why didn't we do better? We're about to come up on an appropriation season, which is often our opportunity collectively to do better, have all voices heard. I want to make sure we've all gotten ourselves in the right philosophical place to do that together, because it is always it is just as easy to, probably easier, to lose that opportunity than it is to gain that opportunity, because there are always folks sitting in the wings saying, oh, no, you can't do this, you can't do that, to both the gentlemen's points. We could have done things differently. We just might argue we shouldn't have done things differently in the case of Mr. Walz's bill, because there are lots of folks counting on it. So please know I'm associating myself with the gentleman's comments. I'm just trying to find a way to to discuss it, to discuss it when we have an opportunity to build some unity on it. My experience is success begets success, and let's put some points up on the board together. My friend from Massachusetts doesn't share my optimism, but he's been here longer than I have, so my optimism prevails.
The speaker made a promise at the beginning of the session, and that promise has not been kept. And I've seen no evidence at all, none, to try to reach out and to try to be more accommodating. I appreciate that there's not a slight against the chairman, but the bottom line is we have been confronted with a very, very closed process. And you know, you can do it because you're in charge, and it's easier to do it that way so that your members don't have to vote on things or you have total control of the process. But let's not kind of get onto this. Let's not try to fool anybody into believing that somehow we're all trying to make an effort to open things up, because I don't think that that's the case. That's my conclusion, and it may differ from yours, but I've been here a long time, and I've seen what's been going on here, and we've been raising these issues because the trend seems to get worse and worse and worse and worse. And so I hope that changes, and until it does, we're going to continue to raise these issues. I thank the gentleman for yielding. I yield back.
Having made my pitch to try to find more common ground, and in lieu of finding the partisan edge, I feel I have gotten a response to that question, though perhaps not the response I'd hoped for. Mr. Chairman, I yield back.
I thank the gentleman for his comments, and the gentleman yields back his time. I want to say this: at no time have I considered that people were aiming at me at all. And I do respect and appreciate not only the confidence of personal relationships that we share here, but I do sincerely acknowledge that I have understood the conversations that I've had with each of you about a frustration, about a process, about hearings, about new members, about the opportunity for them to be given really full opportunity to understand not just what they're doing, but to be fully participatory. The gentlewoman looking now at Mrs. Slaughter knows that sometimes I have my hands tied of certain things. That gentleman, Mr. Barr, did not find that both of his amendments were made in order, even though I think under his eloquence, he should have, just by the courage that he brought up here in the argument, that did not prevail. And so I think we recognize some maybe frailties in the system and some frailties that are inherent. And I thank the gentleman. I also want to thank the gentleman, Mr. Woodall, who I believe tries to aim for congeniality, not only in support of this confidence, because when we go behind a closed door, so to speak, we offer content that would be about trying to make more things in order, about trying to make the process fair. Our deliberation and our words do matter.
Mr. Chairman.
Yes, sir.
It's been a long time since I've said this, and there are 2 or 3 members that are here that haven't heard it. I used to play in a poker game, and when this fellow would lose, his name was Clarence Glasgow, he would leave and we would tease him because he lost his money. We'd tell him, Clarence, tell him where you got your money from. And he would lean back into our little poker room and say, I want to remind y'all, the wind does not blow up the same dog's tail always.
Well, or the way I say it, we all live in a glass house.
All right.
Glass house. So I want to thank the gentleman from Georgia for his, I think, words of support also. Thank you. Is there further discussion? Gentleman from Colorado. I'm sorry, I did not see Mr. Buck, but gentleman was recognized.
I was going to ask my friend if you could add another column to your chart on the rules. I lost 20 minutes of my life today listening to another privileged motion on the president's tax returns. And I'm wondering if you can add a column on that chart, keeping track of the number of times we've had to listen to the privileged motions, the exact same privileged motion over and over again. I don't think any of us on this committee are getting any younger. And to listen to the 20 minutes a couple times a week for a few weeks, I don't know if we've had more privileged motions that everyone knows are going nowhere or more closed rules. But it would be very interesting to see a column just keeping track of that.
And I would urge you to understand the uniqueness of the situation. I had the good fortune of offering a privileged resolution that was made in order to impeach Kenneth Starr. So it is necessary that we bring it forward. And while we're keeping that list, like the gentleman, I lost those same 20 minutes that you lost. But I have a view that the president ought to release his taxes, period. And until he does, I think you will hear more of those resolutions offered, and you and I are going to lose some more time listening to it.
How many,
We live in
reclaiming my
hope.
time, how many times did you have to offer your privilege resolution on Kenneth Starr?
One.
Thank you.
And that's.
And that was under Democrats.
But I would simply say
Made that in order.
That's the case that we've been trying to make here. If you open things up, we don't have to do privilege resolutions. I mean, I've done privilege resolutions on trying to force a vote on an AUMF because we've been at war forever and we don't debate it. But we can't get anything made in order in the Rules Committee that would allow that debate. So what other opportunities we have? Same thing with the president's tax returns and probably a whole bunch of other stuff. So if we have a more open process, you will see a more collegial House, and you will see less and less of those privileged resolutions. But until then, you're going to see more of them. Thank the gentleman.
Does the young gentleman from Windsor, Colorado, yield back his time? You're getting younger. You're getting younger.
We give you back those 20 minutes.
We'll give you back that time. Okay, we have now gotten to the point where I'm going to move the motion that is on the
I'm so
table
glad.
from the gentleman from Oklahoma. So is there further discussion? Seeing none, we will now move. Those in favor of the motion from the gentleman from Oklahoma, please signify by saying aye. Aye. Those opposed, no.
No. Roll call, please.
The ayes have it. The gentleman seeks roll call vote. The clerk will poll the committee.
Mr. Cole. Aye. Mr. Cole, aye. Mr. Woodall. Aye. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Collins. Aye. Mr. Collins, aye. Mr. Byrne. Mr. Newhouse. Aye. Mr. Newhouse, aye. Mr. Buck. Aye. Mr. Buck, aye. Ms. Cheney. Ms. Slaughter.
No.
Ms. Slaughter, no. Mr. McGovern.
No.
Mr. McGovern, no. Mr. Hastings. No. Mr. Hastings, no. Mr. Polis. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total.
7 yeas, 3 nays.
The motion is agreed to, and the gentleman from Louisville, Texas, Dr. Michael Burgess, will be handling this for Republicans,
And Mr. Polis for the Democrats.
and Mr. Post will be handling this for Democrats. I want to acknowledge that there are no meetings scheduled later in the week. Secondly, Louise, I want to thank you for taking time, as you always have, to say hi to our students, but we've got more of students that are here under my intern program, and I'd like to identify them first. My number 4 baby boy, Liam, who goes to Baylor University, the boy with the big smile back there. Liam is a sophomore at Baylor University. We have Lauren Lucas, who is from Baylor University. We have Max Mahari, who is from Augustine College. Boy, I'm going to get better at this. How do I say it? Augustine. Okay. Augustana. The gentleman corrects us. Thank you. Lauren Reed, the gentlewoman who's on the golf team from St. Mary's College. The gentleman, Samuel Ekholm, United States Air Force Academy. Pretty cool. Reed Alexander, Swanee, class of 2019. Ben Roberts, Texas A&M. Jeremy Hartley, St. John's. Grant May, University of Northern Colorado. Yeah. He won't get buffaloed. Walker Thomas, a dear friend of mine who I've known since he was in high school, University of Mississippi, just graduated, fine young man. And there were several others, but I do not have their names down. And I just want to acknowledge to each of them that what they've witnessed today is a very important part of the legislative process of the United States House of Representatives. And it is our ability to work through issues that are very intricate and special, that impact millions of people back home. We brought members of Congress up here to testify. Republicans and Democrats agreed, disagreed, but made our points well known, had an opportunity to effectively have our say. We will now move this legislation forward to the floor of the House. It'll be there. Please, Louise.
We really live in interesting times, and I know that all of you are going to be up to it. I'm really proud of you. There's nothing more exciting for all of us to see the crop of young Americans coming up to take our place. So best of luck to every one of you. I'm so sorry none of you crossed the Mason-Dixon line, but we're pretty good up there, too. Think about New York sometime when you want to go to college. You did? All right, that's great. Where? Ah, good. And you as well. Good for you. I'm not going to ask you why you didn't go to school in New York. I'm too polite to do that. But I'm just proud of you. Thank you, all of you. I think we've got a good future ahead of us. Thanks so much.
Thank you very much, Mrs. Slaughter. We appreciate it. By the way, just so we know that is Mrs. Slaughter that has her picture up there from serving as chairman of this committee, her service to not only the United States Congress, but service to this committee as chairwoman. And I was here the day we put that up here.
You were very kind to lend us the room, and we had great.
Yeah, we sure did. So
I've got to go because
I
I've got
would.
a New Yorker.
I would. Is there any other business before the committee? Seeing none, we've now completed our work for the week.